Morning all. As Hayley's introduced, I'm James Brown, one of the solicitors at SEN Legal. Let me just share my screen so you can actually see the PowerPoint. Can everyone see that? Yeah, brilliant. So like Hayley said, I'm going to be talking about very much the beginning of the process all the way through to an EHC plan, and then very much up to an SEND tribunal appeal as well. So the sort of key points of that are very much the EHC needs assessment process itself, how you can make an application, what the timescales are in the process involved, what an EHC plan should look like, the contents, the provision of it, and the enforceability of it, and then importantly, the appeal process, should you have to go to the SEND tribunal appeal. So to very much kick off, just to sort of say this talk will very much link into other people's talks today as well. So it'll give you a very good solid understanding of the principles behind other people's talks today as well. So it should prove very useful to you. So just to kick off really in terms of what an EHC needs assessment is and how to apply for it. But firstly, just to look at why do you want to apply for an EHC needs assessment? Why do you want an education, health and care plan? And there's sort of the key component comes down to is the fact that there are two classes of children, those with an EHC plan and those without. And the key difference is what children are entitled to from this. So EHC plans provide entitlement and enforceability. If your child does not have an EHC plan, your child does not have protected provision in place. So your child may be receiving support from your school through its own resources, maybe on the SEN register, just receiving some support. Unfortunately, in that circumstance, if the school, for whatever reason, had a budget cut or decided that your child no longer needed that provision, then you have no enforceability of that. You have no right to appeal against that decision. You have no right to put that provision in place. Whereas if you contrast that to an EHC plan, for example, whatever provision is within the EHC plan, it has to be provided by the school or local authority. And if for whatever reason the school or local authority don't provide it for you, you have a right to challenge that and enforce it through the courts. So therefore it provides your child with protected provision as they move through the education sector. So as they move schools, regardless of the school they attend, your child will carry on receiving that provision. And so that's the sort of key difference in why you'd want an EHC plan. So the first step to obtaining an EHC plan is a request for an EHC needs assessment under Section 36 of the Children and Families Act. Any parent, young person or school can request an EHC needs assessment. Importantly, it does not have to be the school who requests this. So you do not need to wait for your SENCO, for example, to request an EHC needs assessment for you. And your SENCO may actually say, well, I don't agree, your child doesn't need an EHC plan. Well, actually, that's not correct. You don't have to wait for them to do it. You can do it yourself. You're very well advised to do it yourself if the school is saying no. The application process itself doesn't have to be a laborious one. So if you go on your local authority's website, often the form you have to fill out in order to do an EHC needs assessment request will require lots of information, and actually you don't need to provide that. There's no requirement within the legislation to fill out any particular form. One simple A4 page is a valid application. So you don't need to worry about the forms itself. One point just to point out, obviously with the COVID-19 outbreak and the impact that's had, local authorities excuse me, are telling parents that they will no longer consider EHC needs assessment requests, for example. And that's not actually the case. Local authorities still have to consider these requests. And I won't go into too much detail about the COVID-19 implications because my colleague Hayley will be talking to you about it in detail. But it's just something to be aware of at this stage. So what is the legal test for an EHC needs assessment? What do you need to concentrate on when you apply for one? And it's very much set out in Section 36 of the Children and Families Act, which is that the local authority must secure an EHC needs assessment if the authority is of the opinion that the child or young person has or may have special educational needs, and B, it may be necessary for special educational provision to be made for the child or young person. And so therefore it's not a definitive answer at that stage. You don't have to prove definitively that your child has special educational needs or that they need special education provision. It's very much a may, which translates to a balanced probabilities test, which is a low threshold to pass in practice. And the key sort of argument where it tends to fall with local authorities is Section B of that test, which is whether it may be necessary for special education provision to be made. So might it be necessary? And when you're looking at that, you really need to know what necessary means in order to be sure as to what you're applying for and how to apply for it. So looking at what necessary actually means, and there's no set definition within the legislation. However, it has been usefully defined in the case law. And what the case law says is that the word necessary falls somewhere between really useful and essential. What is necessary is a matter to be deduced rather than defined. Its determination will vary according to the circumstances of a particular case and involves a considerable degree of judgment. So therefore, what you need to be looking at is what your child needs and what individually the provision they require. It's not to use a set policy to do this, it's very much looking at the individual circumstances. And a very more recent decision on this was a recent decision of this year against Nottinghamshire County Council. And the barrister representing the parent was actually Charlotte Hadfield, who's talking to you next. And what the court held there is what is necessary is an evaluated judgment based upon the specific facts of a particular case, which are for the tribunal to deduce from the evidence in each case. So therefore, it supports the two previous cases, and it very much supports the fact that it comes down to individual need rather than any set policy the local authority may have. Looking at what local authorities will tell you about this and whether or not they will comply with the test properly and use the case law properly, unfortunately, it's usually not the case. And statistically speaking, 1 in 4 of you are likely to be refused your request nationally. But when you look at that more specifically to local authorities across the country, for example, in some cases that's actually 50%. So 1 in 2 of you will be refused your EHC needs assessment. And there's a lot of false information given by local authorities in these decisions to parents, a lot of false information given to schools and parents before they apply in order to deter parents from making these applications. And you really should just ignore these false information and be sure and look at the test, which is in section 36. So just some examples of that, and some of you may have had these examples given to you in a decision, for example. One example is we don't recognise independent EP reports, we only accept NHS and A1s. That's unlawful for the local authority to do. They have to consider independent expert evidence. And for example, if you end up in the SEN tribunal, they will afford them the same way as they will local authority ones, and sometimes even more. Secondly, any child who does not need 12.5 hours of support is not entitled to an EHC plan. Again, that is wrong. The test is in the section 36 of the Children and Families Act, and there is no 12.5 hour threshold in legislation. It is about individual needs and individual circumstances. Policy cannot apply to every single child. Thirdly, the social care, that the provision you're after is social care and not education. Again, that's incorrect, and what you need to look at is the actual definition of special education provision, which is in section 21 of the Children and Families Act, which specifically states in relation to social care and healthcare provision. Any social care provision or healthcare provision which educates or trains will be held to be special education provision and should be provided for within an EHC plan. So therefore, you need to look at the individual facts and what that provision actually is and whether it's educational. And lastly, on the slide is that you have to be X number of years behind your peers, or that your child is making academic progress and therefore they don't need an EHC plan. Again, that's wrong. Local authorities should be looking at the individual needs of the child. And actually the code of practice is quite helpful here. And paragraph 6.23 of the code of practice refers to this point and actually points out while there are other needs that may be not being addressed. Just because a child is making academic progress doesn't mean there are other needs not being addressed. And the local authority should look at that when applying for an EHC needs assessment when making their decision, because the test is one of necessity and what the child in fact requires. So that's very much how you make an EHC needs assessment request and what underpins making an EHC needs assessment request, what you need to focus on. So once you make that request, certain timescales then kick in. The local authority have to do something. And what the process is as follows. The local authority has 6 weeks to make a decision. If the answer is no, you have a right of appeal to the SEN tribunal and you'll be well advised to use it, which I'll come on to later. At 16 weeks from the date of your request, the LA must decide whether they will issue the EHC plan after the assessment. Again, if the answer is no, you have a right of appeal to the SEN tribunal. And at 18 weeks, the local authority must issue a draft EHC plan if they decide to issue an EHC plan. And you have 15 days to comment on this. And then finally, the EHC plan must be finalised within 20 weeks of the date of your request. If you are unhappy with the contents of it, you again have a right of appeal to the SEN tribunal. And what I would say is time is very much of the essence there, because as you can see, it's a 20-week process at best. If for whatever reason the local authorities say no to you at any stage, which is relatively quite likely, that then adds additional weeks to the timetable. So you're looking at 20 weeks at best, which is a long time. So you need to make these requests as soon as you possibly can. And importantly, the deadlines should not be extended and they should not be missed by the local authority. If the local authority do miss a deadline and they don't give you a decision in time, this can actually be quite easily resolved by a pre-action protocol letter, which is a formal legal letter to the local authority legal department, setting out what they've done wrong and why they haven't complied with legal duty. And usually that gets you a response 9 times out of 10, and you can get your right of appeal, for example, if that's what you're after. However, that being said, with the COVID-19 legislation, this has slightly changed position. And like I say, Hayley will go through that in detail with you, but it's just something for you to be aware of at this stage. So looking at the EHC needs assessment, if the local authority decides to go ahead with it, what should happen during the EHC needs assessment? What does that look like? Well, a full EHC needs assessment needs to be carried out. And Regulation 6 in Special Educational Needs and Disability Regulations provides what the local authority must do and what advice they must seek. And so, for example, what they must seek advice from is yourself as parents, advice from the head teacher and SENCO at your school, any medical professionals working with your child. An educational psychologist must have input to the EHC plan, to the assessment, and any social workers working with you, and any hearing and visual impairment specialists where relevant. And what that looks like in practice is very much a parent will be consulted, a head teacher will be consulted, and an educational psychologist will be consulted. That's very much what the local authority has to do as a minimum, and that's what they tend to do. So, for example, they won't tend to carry out a detailed speech and language therapist assessment, even though your child may well need one, because there's nothing requiring them to do so in special educational needs regulations. So that's what an EHC needs assessment should look like. But then when you start to, if you do receive an EHC plan, you need to know what it looks like and what it should contain. And the EHC plan is a complex document. It ranges from 12 parts, Section A to Section K. And the most important points, the most important sections are highlighted on the slides, and they are Sections B, Section F, and Section I. So Section B is all the child's young person's special educational needs. All the details must be, all the special educational needs must be listed in Section B. And it's much like a doctor's note. And then Section F leads on to that, which is the special education provision required to meet those needs. And it's very much like a prescription from a doctor, for example. And then Section I is the school that is named in the EHC plan, and that must be able to meet your child's needs and deliver the provision in Section F. And these sections are the most important because they're the ones that are enforceable to the tribunal, and they're the ones that are legally enforceable through pre-action correspondence as well. So if your Section B is lacking in detail as to what your child's needs are, then it's very likely that Section F is also going to be lacking in provision, because if the needs are not specified, the local authority does not have to provide provision in Section F. And if the provision in Section F is lacking, then it's very likely that your school of choice may not be named by the local authority, because any other school will be able to deliver the provision if there's no provision to actually deliver in the plan. And like I say, they're the enforceable section. They're the ones that you can appeal to the SEN tribunal, so they're very much the ones you need to focus on. And often parents will focus on Section A, what their views are, for example. And it's important that you don't get too distracted by this and focus on Section B and Section F to ensure that the EHC plan is good enough moving forward. That being said, Section E, the outcomes can also be looked at by the SEN tribunal if you go to appeal, so you can have those amended. And you can also look at the health and social care sections under national trial, which has been in place from April 2018, which I won't go into too much detail here because I know Jennifer is talking about it later to you. But that's very much what you need to look out for your EHC plan. And Section B and F need to be detailed. So what happens in reality, what happens when you do get these EHC plans from the local authority? Often the EHC plan is actually an empty document. Sections B and F are usually void of any detail, and they lack the specificity and quantification required of EHC plans. And often the LA have named their choices for the Section I and completely ignored your request for replacement. And importantly, looking at an EHC plan, all sections must be specific, detailed, and quantified. And that's known to more so important in Section F. Because if your Section F provision is not specific, detailed, and quantified, it risks the provision being included within it actually unenforceable. So if there's not specificity, it becomes very difficult for you to enforce if the local authority choose not to provide that provision. So some examples of that, for example, is access to speech and language therapy, for example. Access to speech and language therapy does not say how long or how often your child should receive that therapy. Benefit from occupational therapy, for example. So your child may benefit from something, but it does not say that your child needs it. An education, health and care plan should deal with need, not what your child may benefit from. So you should look out for wording such as that. Another example is opportunities for one-to-one support. Opportunities does not provide provision. Opportunities could mean anything to any different person. For example, how often will that one-to-one support be provided? Is opportunities every day? Is it per week? Or is it even termly, for example? And who is providing that one-to-one support? And they're very good examples of what wording you may have in your HC plan now, and which are actually not specific enough to be enforced. And you should look at amending those, amending that provision within Section F of the HC plan. So looking at what specific and quantified actually looks like, what does it actually mean, and what should actually be in your EHC plan? Well, specific should be so clear that it leaves no room for doubt as to what has been decided and what is needed in the individual case. And that's the case with Adam Clark and Somerset. A further case on the issue is B&M and Oxfordshire County Council, which says the bed provision programme is inadequate as specification of provision. So listing a load of programmes in your child's EHC plan without specification is not sufficient for an EHC plan. It needs to be detailed and it needs to be specified. So examples of that and what you should be looking for and what you should be asking when you're looking at the EHC plan, and specifically Section F, is, for example, who is to provide therapy? What is their skill set? How often it should be provided? Is that in terms of hours, weekly, monthly, etc.? And what is the maximum amount of children in the groups? And a good example of some specified and quantified provisions set out below. So 1 hour per week of direct one-to-one speech and language therapy with a HCPC registered speech and language therapist experienced in working with children with severe autism. That is a good example of specified and quantified provision, and that's what you should be looking for in your EHC plan. When you contrast that to the access to speech and language therapy example, you can start to see what specification looks like and how that should be implemented in your EHC plan. And without that level of specification, you risk it not being enforceable. So looking at what provision parents can actually ask for. So as I mentioned, therapies, for example, can be included. The one-to-one support, any specialist teaching can go into Section F of the EHC plan, but it's also important to remember the redefinition of special education provision. And that's the Section 21, subsection 5 definition. And that's where the health and social care provision, which can be included as educational provision, can be included in Section F as well. So that means working day curriculums, behavioural management programmes, therapies, life skills, e.g. travel training. It can all be included within Section F and does not require any part funding from health or social care. All provision in Section F has to be carried out. The local authority has an absolute duty to provide the provision, and that's under Section 42 of the Children and Families Act. So whatever is in the HC plan, your local authority must provide it. However, in current circumstances, that has been temporarily relaxed to a reasonable endeavours duty under the Coronavirus Act. Again, it's just something to flag, but my colleague Haley will go through a lot of detail with you about what that actually means in practice for you. So an important point in relation to provision as well is that if the school are unable to deliver the provision, the local authority must do so. So schools should not simply pretend they can meet need and provide provision if in reality they cannot do so. It does not help your appeal and it does not help your children if schools do so, so you need to be keeping a close eye on what is actually being provided. And looking at Section F, for example, as to what you can ask for in terms of school options, and that ranges from a number of things from mainstream with a unit, LA special schools and independent special schools and independent residential schools. All can be named in Section I of the plan, and the local authority will be under duty to fund the placement. So that's very much what the EHC plan should look like. But if you get your EHC plan and you're not happy with it for whatever reason, or you've actually been turned down for an EHC needs assessment and your local authority is refusing to give you an EHC plan, what is the option next? And the option next, in my advice, is an appeal to the SED tribunal is the most effective and efficient way to overturn that decision from the local authority and in order to change the content of your EHC plan. The other alternative is trying to negotiate with the local authority, but what you're asking a local authority to do is overturn a local authority decision, with no new evidence to support your case at that point. So you're best advised, rather than spending months and months trying to negotiate with local authority to try and overturn their own decision, which you can already see the difficulty arising there, is that you're best to go to the SEN tribunal, where an independent judge will make a decision on it, and it can prove far more efficient and far less stressful than trying to pursue negotiations, which takes months and months with a local authority officer. So looking at what the tribunal process actually is, and the process is very much the same, whatever appeal you're doing, so be that a refusal to assess or against content of the EHC plan appeal. You will get a right of appeal letter from the local authority, whether that's enclosing your EHC plan or whether that's the refusal to assess letter. You have 2 months in which to submit an appeal against that decision, and you must obtain a mediation certificate in that time. And the mediation certificate can actually extend your right of appeal. So if you're sitting there thinking, oh, I've only got a few days left to appeal my decision, you can obtain more time for a mediation certificate because your right of appeal extends to whichever is the later date between the two. Once you've got your mediation certificate and you're ready to submit your appeal, you have to fill out the form the tribunal sets, and you need to go on the website and fill it in and send it off to the tribunal. A top tip and a practical tip is the boxes they provide for you to set out your reasons for doing so. There is not enough room for you to set out your case properly in those forms. You need to set it out on a separate sheet and you need to provide detailed reasons. Trying to do it on the forms provided by the tribunal is not going to be sufficient. You're not going to be able to do that. So once you've got your appeal into the tribunal, local authority will have to respond to it. And that's roughly around the that's roughly within 4 weeks of submitting your appeal. And they'll set out whether they agree to the appeal or whether they continue to oppose it. The next stage is the further information stage, which is roughly around the 8th week of the appeal timetable, and that's where your case needs to be fully prepared with all the evidence supporting your case, and you need to serve that to the tribunal. Any evidence served after that stage is considered to be late evidence, and it's not guaranteed the tribunal will actually look at it. So you need to make sure your case is prepared properly and prepared by that date. And importantly, local authority will also have to do that as well. After that is the hearing, and that's usually around the 12th week of the appeal timetable, but that is taking longer in some circumstances at the moment. And importantly, due to COVID-19, it's actually gone to a virtual courtroom. So rather than turning up in person, it's now being held virtually online. And I know John Free will talk to you about that in detail later today. So after the hearing, you won't get a decision on the day. You'll get a decision once the tribunal have time to consider it, and they aim to get it out to you within 2 weeks of the hearing. Unfortunately, in practice, that's looking more and more like 3 to 4 weeks rather than 2 weeks that the tribunal aims for. So just looking at key points to consider when appealing to the SEN tribunal. And the process is the same whatever age, however every case is different. One size does not fit all, and the evidence in each appeal will be different. So if you're appealing against the content of an EHC plan for a dyslexic child in a mainstream school, the evidence you obtain is going to be very different if you are appealing for a severely autistic child who has severe challenging behavioural difficulties and might need a waking day curriculum with a residential placement. The evidence will be different, the process will be the same, but the legal test is individual need and what is necessary in an individual case. Your evidence must be targeted. And the key issue is the critical mass of education provision required. So what is it and how much does it cost? And the tribunal needs to be aware of what it's going to cost. So you have to present that information to the tribunal. Importantly, the appeal does not suspend the EHC plan. So if you've got provision within the plan, that very much continues whilst you submit your appeal. So the local authority can't just turn around and say, well, you're appealing, so we're not going to fund that anymore. That's very much not the case. The local authority have to continue to fund it. Looking into a bit more detail about Section BF and I appeal, for example, the SEN tribunal has the power to completely rewrite the EHC plan. So whatever your EHC plan says at the moment, or whether or not it contains provision in the wrong places, that doesn't matter because the EHC plan can be completely rewritten. And that's very much done through the working document, which is a Word copy of your EHC plan, which the local authority will provide to you. And you can make as many amendments to it as you like, based on what your expert's advice is. And the local authority will signal what they agree to and what they do not agree to. And it's very much like a negotiation, so it will go back and forth between you. It's very much like a game of ping pong almost. So you'll set out what you agree with the tribunal, and the local authority will set out what they agree with. Anything not agreed, the tribunal will then decide on at the hearing, for example. A common mistake, I would say, is that parents only appeal against Section I. And this is very much pointless. If a change of placement is required, changes to section B and F are almost inevitable, because if your child's needs are not being met, it very much states that section F needs to be changed in order for the provision to be put in place for your child's needs to be met. And if the provision does not support the school placement that you're seeking, then the local authority aren't going to name the section I, and the tribunal likewise. Section F very much has to support your school placement. So therefore, it's incredibly rare for section I only to be necessary to be appealed. So I'd very much look at that in a lot of detail before submitting your appeal. In terms of running an appeal itself, the SEN tribunal are very much judicial proceedings. While they try to be as informed as possible, there are rules to follow and procedures to follow. And the first tier tribunal rules very much govern what the local authority should be doing and acting, and how you should also be acting through the appeal process. So you'd be well advised to have a look at those. These SEN tribunals are evidence-based, so your evidence must be relevant and appropriately targeted. So stale old evidence will not assist. And what I mean by old evidence is an EP report, for example, which is 2 years old, will not tell the tribunal what the child or young person's needs are at the date of the hearing. It will set a good background, but you will need updated evidence to say what your child's needs are at the date of the hearing. If you don't have that, you are facing an uphill battle. Evidence is key, and any parent who can afford good independent expert evidence is well advised to obtain it. And what we mean by independent expert evidence is independent EPs, for example, speech and language therapists, and occupational therapists, and even social workers, for example. And the SEN tribunal will consider the independent expert evidence. And importantly, the tribunal will not go over background, who wrote what, to whom, and when. And it's not advisable for you to focus on these points. You need to focus on what your child's needs are and what provision is required. Sending reams and reams of paper to the tribunal about what your local authority have done in the past is not going to get you very far, and it risks the tribunal not being able to see the wood for the trees. So you very much need to focus on your child's needs rather than what's gone before. And finally, just on expert witnesses, because they are key. And if you are going to challenge what you have been offered from the LA, you'll have to pay for independent expert report, because the LA's EP is very much going to turn up and support what the LA is saying. So if you're going to challenge that, you need to have independent experts in order to do so. And importantly, experts cannot credibly exceed their area of expertise. So for example, a speech and language therapist cannot comment on what occupational therapy your child needs. You need an occupational therapist to do that. Parents need good independent expert reports to say what expert help is needed, how much and how often. That links back to the specification and quantification point. And your expert's recommendations need to be at that level in order to go in the EHC plan and in order for the tribunal to name it. And once that is in the EHC plan, the local authority will be under duty to provide it. So just to conclude on that, that's very much a run through the process, and very much to sort of end on a high, because that may sound a little bit daunting to you, but the statistics show that SEN tribunal is in the parent's favour. A well-prepared appeal with good expert evidence is likely to succeed. So you can take on and challenge the local authority, and the odds are very much in your favour. So for example, parents in 2019 had an 89% success rate against local authorities. For example, we had a success rate of 98%. So the odds are in your favour, and you've got a very good chance of overturning that decision as long as your appeal is well prepared and you have good expert evidence. So that's very much it from me. I hope it was helpful, and I thank you for listening. I will now be passing over to Charlotte Hadfield from 3PB, who's going to be talking to you about the working day curriculum and extended day curriculum.